Dear all, welcome at this seminar, which is organized by the Global Detention Project. And as we just heard, I'm the international coordinator of La Strada International, which is a European NGO platform against trafficking in human beings. And we unite 30 anti-trafficking NGOs in 24 European countries. Very shortly, our members provide access to adequate assistance and support to trafficked persons and related vulnerable groups. And we work on raising awareness, information and knowledge exchange, capacity building and cross-sectoral cooperation. But also we do a lot like the Global Detention Project on advocacy to ensure more accountability for the effective implementation of European anti-trafficking policies and regulations, including also the non-punishment provision, which application in practice we are trying to promote all over Europe. So I'm extremely glad that we have this webinar today, because despite international and European legal binding standards on non-punishment and the adoption of specific legislation in several countries, both in Europe but also beyond, as we will hear today, trafficked persons are often still wrongly detained, prosecuted and punished for offences they have been compelled to commit in the course or as a result of having been trafficked. But today, we try to look together what can be done. During this webinar, with the title, What Does the Principle of Non-Punishment Mean for Victims of Trafficking and Immigration Detention?, we will hear from 4 global experts on human trafficking about how the principle of non-punishment can specifically be used to protect victims of trafficking who are detained for migration-related reasons. And this webinar comprises 2 parts, or 2 panels, if you can say. Firstly, during panel 1, we will look into the international legal and organizational framework with the UN Special Rapporteur on Trafficking in Persons, especially women and children, Professor Siobhan Mullally, and also with Ms. Tiffany Gritted from the Human Trafficking and Migrant Smuggling section at UNODC. Unfortunately, Siobhan Mullally has to leave at 10:30, and so immediately after her presentation, we will allow you all to raise questions in the chat, and we then try to have her answer your questions. But our colleagues are also present with us today, so in case the rapporteur has left, there's still time also for them to answer your possible questions. The second panel will then look into the regional and national perspectives, and we will hear from Ambassador Yuyun Wayung Gingrum, sorry if I pronounce your name not fully correctly, the chair and the representative of Indonesia to the ASEAN Intergovernmental Commission on Human Rights. And lastly, Catherine Meredith, the barrister of Darty Street Chambers in the UK. During both the panels, we will discuss the issues like, and you saw that also on the flyer, what is actually the principle of non-punishment and how does it relate to immigration detention? How are existing international standards used and how can they be more effectively used to prevent the detention of trafficked migrants and refugees? And also how, because we know that many of the people that are now online are civil society representatives, how can we engage with international organizations to protect the victims of trafficking? What are the global trends in protecting victims of trafficking from migration-related detention? And also what can we learn from the different regions, in particular also the Asian region, ASEAN region, where the principle of non-punishment has been integrated already in national legislation. The same goes actually for some European countries. And lastly, we also hear more about the new, unfortunately, the new UK illegal migration bill and the withdrawal of protection under the Modern Slavery Act in the UK and what this means for victims of trafficking there. I will still introduce both panels shortly and also all the speakers further, but without further ado, I would like first to give now the floor to Mike Flynn, the Executive Director of the Global Detention Project, for some opening remarks. And Mike is the co-author of Immigration Detention in the European Union in the Shadow of the Crisis, and also co-editor of Challenging Immigration Detention, Academics, Activists and Policymakers. And he previously worked as a project director at the Institute for Policy Studies in Washington. Mike, I leave it here and the floor is yours.
Thank you, Susan, for that introduction and also for the introduction to the webinar today. I also want to take a moment to thank my colleagues, Rachel and Katie, for organizing this event. It's been an enormous amount of work and you've done an excellent job, so thank you. It's a pleasure to welcome you all here today to this Global Detention Project webinar, focusing on 2 extremely harmful yet seemingly intractable issues impacting the health and well-being of migrants, refugees, asylum seekers, including victims of trafficking in nearly every corner of the globe today, detention and human trafficking. This webinar is the fourth in the GDP's webinar series aimed at sensitizing migrant rights advocates to tools at the international and regional levels that can be used to push back against harmful migration-related detention, as well as to ensure that human rights bodies take into account the views of advocates and victims and are aware of the applicability of their mandates to the issue of immigration detention. Our previous webinars in this series have all been animated by human rights norms and principles that undergird the work of specific human rights mechanisms: the prevention of arbitrary detention, the protection of the rights of migrant workers and their families, and the prevention of torture. Today's webinar also revolves around a critical norm, the non-punishment principle, which is fundamentally important to the protection of victims of human trafficking. As a special rapporteur on trafficking has written, quote, "At its core, the non-punishment principle is aimed at ensuring that a victim of trafficking is not punished for unlawful acts committed as a consequence of trafficking." The non-punishment principle also has important relevance to the issue of immigration detention, which is the unique focus of our work here at the Global Detention Project. In its guidelines concerning the human rights of victims of trafficking, the Office of the High Commissioner for Human Rights states that trafficked persons shall not be detained, charged, or prosecuted for the illegality of their entry into or residence in countries of transit and destination. For more than a decade, the Global Detention Project has worked to document immigration detention policies and practices in every corner of the globe, in every country of the globe, with the goal of developing data and analyses that can be used to protect the human rights of all non-citizens who are subject to arrest, detention, and deportation. We have documented more than 2,000 detention centers detailing conditions faced by detainees, developed statistical and analytical data on dozens of countries revealing the evolution and legal justifications of immigration detention systems, and employed this information in joint initiatives with local advocates in every region of the world in an effort to relentlessly insist that states abide by their human rights commitments in their treatment of non-citizens. Despite the tireless work that we and many others have done for many years to push back against harmful immigration detention practices, what we are witnessing today is an explosion of detention, interdiction, incarceration, and oftentimes disappearance of migrants and refugees everywhere. A week does not pass without reading about another, often nameless migrant or asylum seeker dying in a detention center because they were not given medical treatment or because they merely had given up hope in the face of their endless detention. Although there's no standard or universally accepted definition of migration-related detention, the GDP broadly defines it as the deprivation of liberty of non-citizens for reasons related to their migration status. Typically, such detention measures are imposed to ensure that a person is deported, to verify their identity, to prevent absconding, or as part of an asylum procedure. Although in some cases, immigration violations can lead to criminal prosecution, immigration detention in its most common manifestation involves detaining people without charging them with a crime. This often results in immigration detainees having limited access to due process guarantees or judicial remedies. In contrast to criminal prisons, which are at least nominally intended to lead to the reintroduction of people back into society, immigration detention has no reform agenda whatsoever. Rather, it generally is intended to permanently disappear people from society by ensuring their removal. It is at this crucial juncture between criminal and non-criminal forms of detention where the non-punishment principle has particular relevance to the issue of immigration detention. This is because while it is relatively easy to observe and witness a criminal procedure and the legal process driving it forward, when it comes to immigration detention, the process and rationale for the detention can become deeply blurred and even invisible. In fact, in many countries where migrants, including victims of trafficking, are detained, officials do not even recognize the confinement of these people as detention or deprivation of liberty, let alone as a form of punishment. And yet, there can be no doubt that when you place a trafficking victim behind bars or in a locked room or in a secure border camp, simply because they do not have the appropriate papers to be in that country, you are punishing that person, likely in ways that are indelible, causing a harm that will never go away. It is impossible to imagine the depths of despair that a victim of trafficking must feel when they are locked up without criminal charge, afraid to even acknowledge their victimhood for fear of reprisals by their traffickers, forsaken in a country they do not know. But this is precisely what we need to try to imagine today. How can we harness the power and rationale of the non-punishment principle to prevent harmful migration detention? This is the key question that we seek to address. I am deeply excited to hear from our esteemed guests, whose work and expertise covers much of the globe, about how they envision employing the principle of non-punishment to push back against arbitrary and harmful immigration detention practices. I am equally excited to hear from many of you in the audience about your thoughts and experiences. One of the riches of today's event is its intersectional nature. We have in attendance today a diverse range of specialists, advocates, and practitioners who may have different areas of expertise, but who all nevertheless share a common goal: protecting victims from punishment and harm. Thank you very much for attending. I look forward to our discussion. Thank you.
Thank you very much, Mike, and also for highlighting already the negative situation we currently have with the very harmful migration detention practices all over. I think that's a good start of this panel, that we know what's going on and that we immediately want to see what is possible to address this. So let me start with the first panel, which will, as I mentioned before, focus on the international legal and organizational framework. And I directly move to the first speaker, which is Professor Shifon Mulali, the UN Special Rapporteur on trafficking in persons, especially women and children. She is the established professor of human rights law and director of the Irish Centre for Human Rights at the School of Law, National University of Ireland, Galway. And from 2012 to 2018, she was also a member of the Council of Europe Group of Experts on Action Against Trafficking Human Beings, which is called CRETA, and she was elected as the president of CRETA from 2016 to 2018. And also as first vice president for 2014 and 2018. Ms. Mulali has worked with international NGOs and UN agencies in many parts of the world and is the recipient of numerous research awards for work related to gender equality, migration and refugee protection, human trafficking, and also migrant workers. She's a graduate of the European University Institute in Florence, the London School of Economics, and the University College Cork. Ms. Shifon Mulali, without further ado, I would love to give you the floor and to hear more from you about the legal framework for the non-punishment principle and possible examples of how it's being applied in countries around the world. And also, we would love to hear more about the role of your mandate as a UN Special Rapporteur on trafficking, and also maybe explain how we as civil society organizations can further engage with your office to address this issue. The floor is yours.
Thank you very much. Good morning, Suzanne, and good morning to all. Thank you very much to the Global Detention Project for organising this event, and to La Strada International. I'm very pleased to have this opportunity to talk about the non-punishment principle, which has been a key focus of the work of my mandate and of the mandate of Special Rapporteur on Trafficking in Persons for several years. The non-punishment principle goes to the heart of what we sometimes refer to as the human rights-based approach to combating trafficking in persons. But rather than just simply using that as a slogan, it's critical that we look in detail at what that means in practice. How do we give practical effect to that commitment to a human rights-based approach to combating trafficking in persons? And there, I think the non-punishment principle is at the crux and at the heart of that. It's not found referenced in the Palermo Protocol itself, but I have argued, and I think it is accepted as a matter of international law, that it is at the heart of the object and purpose of the Palermo Protocol, in that it is central to the protection of the human rights of victims of trafficking. We find specific reference to the non-punishment principle in the Office of the High Commissioner for Human Rights, Principles and Guidelines on Human Rights and Human Trafficking. And subsequently, over the last 2 decades, as Suzanne said, and as Michael said in the opening, there have been several legislative developments at domestic level which critically include reference to the principle of non-punishment. And that draws on developments in international human rights law and regional human rights law. And I think too often within the anti-trafficking world, we tend to focus only on the Palermo Protocol without engaging the full range of international law instruments that are applicable to the situation of trafficking and to the rights of victims of trafficking. So it's critically important that we draw on all of international human rights law and international refugee law in particular, which are relevant to this issue of immigration-related detention and how it conflicts with the non-punishment principle. So first, I just want to note that under international human rights law, there is a positive obligation on states to identify and assist and protect victims of trafficking. It is not dependent on self-identification. And critical to that is ensuring that victims are not punished for unlawful acts that are committed as a direct consequence of being trafficked. That is, in a nutshell, the non-punishment principle, but as all of you know, that in itself already gives rise to many questions. What unlawful acts are covered? Does it include serious criminal offences? Does it include immigration-related offences? And how and when do we operationalise the principle? And how do we make the connection with the unlawful acts being committed as a consequence of being a victim of trafficking? And what I have argued in my first thematic report to the Human Rights Council and in interventions in domestic courts, I have argued that it applies to all unlawful acts. There aren't exceptions recognised. But what you then have to look at are the consequences of that. And specifically, I've argued consistently, and including in submissions to the UN Migrant Workers Committee and in other thematic reports, that immigration-related detention should not be applied to victims of trafficking. It is contrary to the positive obligation to identify and assist and protect victims because it prevents that recovery. It goes against states' obligations to assist and protect. It may also lead to the consequence of refoulement if there's a failure of identification of victims, that they may be forcibly returned to a situation where there is a real risk of being of treatment contrary to international law, including of trafficking and re-trafficking. That position has been taken consistently by the Council of Europe group of experts on action against trafficking in applying the Council of Europe Anti-Trafficking Convention, which includes the non-punishment principle. So, for example, in an urgent procedure visit that we undertook to Hungary, to the transit zones, we found that the detention of asylum seekers, which could include potentially the detention of victims of trafficking, was contrary to states' obligations under the convention and under international human rights law. We also argued consistently, and this has also been the position of the UN Committee on the Rights of the Child, that child victims of trafficking should not be held in situations of detention. They require a protective environment, but they should not be deprived of their liberty. And we see the non-punishment principle and the positive obligation and assistance and protection being taken up by UN human rights treaty bodies, by CEDAW, by CERD, importantly, the Committee on Racial Discrimination, by the Committee Against Torture, and as I said, by the Committee on the Rights of the Child. Questions arise as to when does the non-punishment principle kick in? And it should kick in, it should be triggered as early as possible. So not only during proceedings being taken against potentially a victim of trafficking, but as early as possible. So it's closely linked to early identification. But all of the actors involved in combating trafficking need to be able to ensure that any prosecution or punishment is set aside as soon as a person is identified as a victim or possible victim of trafficking. And that includes ensuring that sanctions can be removed, can be vacated, whatever is the domestic procedure, because those sanctions longer term can have a detrimental impact on victims of trafficking recovery. And importantly, in terms of international human rights law, we have the judgment of the European Court of Human Rights from AN and VCL versus the UK, which involved adolescent Vietnamese boys who were identified as victims of trafficking, but nonetheless the prosecution against them for drug-related offences continued. And critically important, the European Court of Human Rights found that that was contrary to the positive obligation to protect victims, but also was contrary to the right to a fair trial. because it meant that relevant evidence wasn't coming before the court because of the failure to assist and identify the victims and instead to prosecute and punish them. So that is really important to make that link across with the fair trial. And I think to conclude, to look at how do we practically give effect to the non-punishment principle, particularly with regard to immigration-related detention, we need to look at all forms of detention, including as a consequence of interdiction at sea. We've heard recently reports of detention on boats, on ships, on vessels, returning victims to countries of origin or transit. We need to ensure that there is effective access to legal aid and to civil society to assist those who are in immigration-related detention, to ensure that they are identified, referred for assistance and not punished. So that is critical, that there is effective access to legal aid and early identification, and that those who are identified, perhaps rescued at sea, are not being held in detention in police stations, where we have seen in Southeast Asia, for example, children being held in detention with adults, not being identified as victims of trafficking, not being referred for protection. We need to ensure that all of those actors, maritime actors, police officers, all healthcare professionals, all those who may have access to detention, are aware of how to identify and refer victims for assistance and protection, and to ensure that they are not punished for any unlawful act, including immigration-related offences. This is a positive obligation on states, and it's critically important that civil society is supported and lawyers are supported in giving effect to that. In relation to my mandate, we receive submissions, and quite often those have related to detention situations, and I have been directly involved in court proceedings as an intervener, specifically with regard to the non-punishment principle, including most recently in the Shamima Begum and the UK proceedings before the Special Immigration Appeals Commission, but also more broadly in other non-punishment cases at domestic level. So if we receive information, referrals from lawyers, we may be able to assist and intervene. The mandate email is available, and my colleagues are online also. I think many of you are quite familiar with how to engage with the Special Rapporteur, but we can provide support. We can also issue communications to states with regard to individual victims or with regard to a policy or legislative development that is regressive. And we have done that on many occasions, including with regard to the non-punishment principle. So thank you again for dedicating this webinar to this core principle of international law, which, as I said, is central to the human rights-based approach. Thank you.
Thank you very much, Yvonne Mullally, also for highlighting that we have to look very critically at what the human rights-based approach means in practice, and for highlighting that next to the UN Palermo Protocol, which you said does not reference explicitly to non-punishment, but has it as its heart and as its purpose. Also that we should use other legal instruments that are there that we can use. You also clearly stated that immigration detention should not apply to victims of trafficking, and it goes against the obligation of states and the principle of non-refoulement, and also for highlighting that the non-punishment should be applied as early as possible, and that any prosecution of punishment should be set aside, and also to look at all of the forms of detention. And lastly, I think very clearly that you said not only should the non-punishment principle be much more known among all the relevant stakeholders, but also, of course, the issue of human trafficking. People should be able to identify people in detention as a trafficked person. So thanks very much. I'm not sure if you still have time for one question. I was looking in the chat, but I would have one question. You mentioned that you already are sometimes called upon in court procedures. Do I understand correctly that, let's say, someone who is here online is assisting someone who's in detention and does manage with their the legal representative and the lawyer to have this case be held in court, that you could give an expert opinion in court as the UN Special Rapporteur to support the case?
Yes, I have done that. An expert opinion or request permission to intervene as a third party, as an amicus, a friend of the court. That's not on any one side, but it's setting out the relevant law, which often is important to bring that specific expertise on human rights law with regard to trafficking in persons. But I have also made expert opinion submissions in relation to a particular case. It is dependent. We have limited capacity for a global mandate. It's very much dependent on reliable and credible evidence coming through and the relevant domestic laws. So it depends very much on the domestic legal procedures and how those apply. And so that's where lawyers or NGOs from the specific jurisdiction who are familiar with the process and who can make submissions to request that, then we can work closely with them on doing that. But I have done that on several occasions. Those submissions are posted on the mandate website also, which may be of interest for people to have a look at as examples. And it varies very much depending on the specific jurisdiction and the procedures in place. But it's a potentially an important tool that can be used. Thank you.
Thanks. There's another question in the chat, but I'm also conscious of your time. So if you cannot answer it, yes, you can still do one question. The question is again to you. It's of course, could you elaborate why you define the non-punishment principle as a general principle of law as defined by Article 38(1)(c) of the Statute of the International Court of Justice in your report in 2021, please, since many countries like Chile unfortunately haven't implemented the non-punishment yet principle?
Yes, thank you. As the report documents, the principle has been laid out in many jurisdictions and also in international law, in the practice of courts, tribunals, legislation, policies and guidelines. It's not uniformly applied, but applied at a sufficient level of generality that I made that argument in the report. So it's based on the developments since over the last 2 decades, and more than 2 decades now, where we see that practice evolving at regional level, at domestic level, and at international level in terms of giving effect to that. So the legal standards are documented in the report, and there are many, many provisions at domestic level to support that claim as well. So thank you very much, and thank you to all of you. I will be stepping in and out, but I'm afraid I just have to step out quickly. Thank you very much. Thank you.
Thank you very much, Yvonne Mullally. And as we said beforehand, I saw that there are some other questions already in the chat, but her colleagues are online. I would suggest we go to the next speaker, and then we still have a Q&A together with the colleagues of Professor Mullally, and also you can then raise questions still both to her mandate, but also to the next speaker. So let me introduce the next speaker, which is Ms. Tiffany Kritin, and she's a crime prevention and criminal justice officer in the human trafficking and migrant smuggling section of UNODC, where she focuses on normative and policy developments. She previously worked on human rights, torture prevention and detention measures, including immigration detention. She will shortly provide an overview of UNODC's anti-trafficking work, as well as the intergovernmental and normative developments, including also in the working group on trafficking and persons. And she will again also explain how NGOs can engage at the intergovernmental level on this issue. She will use a PowerPoint. So Tiffany, I hope you can start your PowerPoint, and the floor is yours.
Thank you so much, Suzanne. And yes, let me see if this works. Can you see my presentation?
Yes, we see it well.
Okay, thank you. So thank you very much for this invitation. I'm very pleased to be here today representing the UN Office on Drugs and Crime on such an important topic, and wish to thank the Global Detention Project for co-organizing this webinar. So UNODC, and in particular my section, the Human Trafficking and Migrant Smuggling section, has been working for many years now on developing the scope of the non-punishment principle at the normative, the policy and the technical assistance levels, really as a pillar of human rights, trauma-informed and victim survivor-centered approach to countering this crime. Our headquarters are based in Vienna in Austria, but we have field offices in 97 countries in the world. And while UNODC works against different crimes such as terrorism or corruption, my section in particular focuses on fighting human trafficking. And we do so by training law enforcement officials, by researching and publishing on the topic, and by assisting states by providing them with technical expertise, or servicing intergovernmental meetings, mostly in Vienna, but not only. So you can see on the slide that so we have various publications on this topic, and one in particular that I would like to show you today is the UNODC Model Legislative Provisions Against Trafficking in Persons, which contains a model provision on non-punishment and includes more than 30 examples of domestic laws that give effect to it. But you see our website underneath, and you can find many more there. So UNODC supports states in their implementation of the Trafficking in Persons Protocol, the Palermo Protocol, as we are the custodian of this instrument, which entered into force 20 years ago, actually exactly, and has right now 181 states parties. And like it was said, despite the principle not being explicitly mentioned in the protocol, there is no article on the non-punishment principle. It supports one of the protocol's purposes, which is to protect and assist victims of trafficking with full respect for their human rights. And this is a key foundation of the non-punishment principle. The concept of non-punishment of victims of trafficking means that persons who have been trafficked should not be penalized for the illegal conduct that they might have committed as a consequence of them being trafficked. And in addition, punishment should be understood widely and beyond just conviction, and can, for example, include restrictions on movement and detention. Of course, it depends on national legislation, but this is at least what we advocate for at the policy level on the side of UNODC. And the basic idea behind the principle is that victims should not be exposed to further harm. They have suffered already enough through exploitation, and they should rather have immediate support and services to avoid being further exposed to trauma. That's also the idea behind the victim and survivor-centered approach, which really puts victims and the needs at the center of government actions. And in the context of immigration detention, the non-punishment principle implies to detect, to really identify the victims of trafficking and refer them to the appropriate services. In any case, victims of trafficking should not be detained. That runs contrary to the principle. And from criminal justice perspective, which is what UNODC usually focuses on, the non-punishment principle helps victims to report crimes committed against them and engage as witnesses in trials against traffickers to eventually stop impunity. So for all these reasons, it's really an important principle. We witness at the intergovernmental level that there is actually a growing number of states that not only agree with the principle and show willingness to implement it, but also that really understand that the idea of punishment has a larger scope. However, we also observe that there are huge challenges in its implementation and practice, and victims are still punished and detained. The first obstacle to the implementation of the principle in immigration detention is really the identification of the victims, as victims cannot be supported, cannot get assistance if they haven't been identified. And we observed in our global report on trafficking in persons, GLOTIP, a document that we publish every 2 years and that we actually just published 2 months ago, that there is for the first time in 20 years a global decrease in identification of victims of trafficking, which is really worrisome. You can see it, maybe it's a bit small, but it's the chart on the right side. If you see the bars, the blue bars, you see a progression in identification and a decrease in the last years. More concerning even, we observed that the victims in the majority of the cases self-rescue from exploitation. So they rescue themselves, they go themselves to law enforcement. And only in 28% of the cases, they are rescued by authorities. So law enforcement, immigration officials, border guards. And that's the chart on the left. You can see the brown dots on the top. It's like when victims go themselves to self-rescue to authorities, and it's 41% of the cases. So there is a clear need to better detect victims, including in immigration detention, so that they get referred to the right service providers. And it's important to note that this is the state's responsibility. It's their obligation to due diligence. It's not the victim's duty. However, one of the challenges that many countries face is the lack of proper training on identification, the lack of knowledge on the side of the officials. So in practice, there is still a large lack of awareness about the principle generally. So in a second part of this presentation today, I would like to briefly present the work of an interesting intergovernmental body in Vienna called the Working Group on Trafficking in Persons, as well as the new constructive dialogue, a new platform, since these two fora offer opportunities to discuss the non-punishment principle and also other relevant topics to human trafficking. The Trafficking in Persons Working Group is a mechanism established to improve the capacity of states to combat trafficking and support the implementation of the protocol, basically by facilitating the exchange of information on challenges, on successful practices. So it's a great way for states to discuss issues since they send practitioners to Vienna as part of their delegations. So the working group meets once a year in Vienna for 2 days, and this year it's going to be on the 2nd and the 3rd of October. However, this meeting is not open to the public, it's just for states. But the reason why I mention it though is because it's an expert-led group, and it's a platform that shows how the position of states has gradually changed over the last years. We really see an evolution. The working group adopts recommendations at the end of its session, which are not legally binding on states, but they still form soft law that contribute to change the discourse. In June last year, in June 22, the working group actually discussed the non-punishment principle. And among the 7 recommendations that it adopted, some are really quite interesting for our topic today. I will not read them all, but maybe just one of them, recommendation number 5, mentions that states parties should consider taking steps to develop and integrate a victim-centered approach to enhance the proactive and timely identification of trafficking victims. If we also read the others, I don't think we could have expected such recommendations even 6 or 7 years ago. And this, for me, shows a growing understanding for this concept and for the issue of identification also. So the second platform I would like to tell you about is interesting for civil society engagement. So in 2018, states decided to establish a mechanism to review the implementation of the Convention Against Transnational Organized Crime and its 3 protocols, including the Trafficking in Persons Protocol. So the review mechanism was then launched in 2020, and it's somehow a treaty body for the Trafficking in Persons Protocol. It's again a state-led process in which states can involve civil society at the national level, but they are not compelled to. So for now, it's having a slow start, so we cannot yet observe trends in the involvement of civil society by states, but we've heard of good practices. And as part of the review, states also decided to include a constructive dialogue with civil society, which are held after the working group on trafficking session. It's also chaired by the same chair as the working group, and it has a panel on a specific topic followed by statements from the floor, and it also adopts recommendations that are then included in a document called Summary by the Chair, which is publicly available. And written submissions by the individual organizations are also uploaded on the dedicated webpage. So the constructive dialogue are a great opportunity to hear from the chair of the working group about what happened in the session, but it's also very good to exchange with states on ways to improve the current situation. We had 1 edition so far. It's brand new. It just started last year. And that first edition had 60 NGOs. So it probably can be improved. So it becomes really, really meaningful and constructive. For example, the first edition was just half a day, but this year we will make it for an entire day as we realized it was really way too short. And we're also planning to add a multi-stakeholder preparatory day, as we call it, the day before, during which NGOs will be able to meet with the chair, hold a side event, reflect on the previous edition, and do advocacy work or networking. So the constructive dialogue on trafficking will be held on the 4th of October this year, and the multi-stakeholder preparatory day will be held the day before. Registrations will be open at the beginning of May and for 5 weeks on the dedicated website that I can actually paste into the chat later. So it's held on a hybrid format, meaning that if you cannot make it to Vienna, you can still participate online, but it's only in English. And in the framework of the review mechanism, the constructive dialogue, I would say, is for now the best path of engagement with civil society, and especially those from countries that are unlikely to be involved in in the review process at the national level. We have a civil society unit at UNODC that also offers online courses and material on how to engage in the review mechanism and to get information about it. I can also give you the references. So in conclusion, I wanted to say that the non-punishment principle is anchored really in a victim survivor-centered approach and can be a good framework to get irregular migrants, victims of trafficking, out of detention. But we see a clear problem of lack of identification of victims by law enforcement, and can only imagine that a huge percentage of victims are wrongly held in immigration detention. More capacity building needs to be provided to officials, and I think in many contexts, stronger partnerships with civil society organizations would certainly help support better identification and referral. And I saw in our list of participants that we have the NPM from South Africa, and I think that would be also a key role for NPMs to assist law enforcement immigration officials in that regard, or at least raise awareness of the topic. At the policy level, I really encourage you to participate in the constructive dialogue on the 4th of October to push for such changes, and don't hesitate to contact me if you need more information. Thank you very much.
Thank you very much, Tiffany, also for explaining that the UN Palermo protocols should be interpreted widely, as we also heard from Shifon Mulali, also as it implies to protect victims of trafficking. And non-punishment is, as you said, much more acknowledged as a principle by a growing number of states, which is of course very positive. Also recognizing that the non-punishment has a much larger scope. Although you also actually highlighted the different caps, again, the lack of identification. Also, as you mentioned in the last UNODC report of 2022, the number of identified figures of human trafficking has for the first time decreased. And you mentioned, and that's what we also heard from the first speaker, there's still a lack of knowledge among the relevant stakeholders who should actually apply in practice the principle. So I think there's also a clear role for all the NGOs here online to promote the non-punishment principle much further in practice, so people are also aware. Thanks also for highlighting more about the trafficking working group, which, as you said, also discussed the non-punishment principle, and for highlighting the dates that are relevant for us to look out for, the 2nd and the 3rd of October for the next working group meetings, but in particular, of course, the UN Constructive Dialogue on the 4th of October. So last year we were there, and also some of our members, and probably also some other people here online, but it might be indeed a good possibility for us to interfere. And just to note, I will also share it in the chat. We have, together with the Global Alliance, last year, we have made some small NGO guidance on the UN review mechanism. So we can also share that in case people want to be more involved in the UN review mechanism. I would now like to open the floor. We have till 11 o'clock for questions to you, but also questions still related to the mandate of the UN Special Rapporteur, because we have two colleagues online, Clara and sorry, I have to check here. The two colleagues online, both from the Secretariat, from the OHCHR, and Clara and Hee Kong Yo. Sorry, I had to look for her name. But before we do, and I also have to apologize, I have been saying, please put your questions in the chat, but actually you should not put them in the chat, but you should put them in the Q&A. So sorry for confusing you. So please do that. Before you are ready to raise more questions to Tiffany or to the colleagues of Shifon Mulali, I would like to first invite Matthew Giller. See, he's a member of the UN Working Group on Arbitrary Detention. He will speak from the floor for about 2 minutes just to explain a little bit more about this UN Working Group. Matthew, can you let us hear your feedback?
Matthew, you should be able to speak now. Maybe we go to Mike, Suzanne, and I'll go back to see if I can sort out why we can't hear Matthew.
Okay, indeed. Mike would also like to speak. So Mike, you can take the floor.
Hi, thanks. And thank you also to Siobhan and Tiffany for those presentations. I have two questions, one for both of you and one more directly for the Special Rapporteur. Perhaps, Clara, you could help with that question. The first question for both of you really concerns the different procedures, or as it were, the constructive dialogues in the case of the UNODC, but the different procedures that you have for the Special Rapporteur as well, for having some kind of interactive dialogue with state parties, or as the case may be with civil society. To what extent can you characterize a recognition of immigration detention as an issue that is broadly recognized by states with respect to the non-punishment principle? Or is it something that to date seems largely focused when people think about the principle, the non-punishment principle, on criminal procedures rather than immigration procedures? Because I think one of the concerns that we have at the Global Detention Project is there is this principle that does have relevance, but it probably is likely often seen largely within the criminal context and not the administrative one. That's the question for both of you. It'd be great to hear back from you on. The other question I have, which really is specifically for Siobhan, for the Special Rapporteur, concerns the issue that she raised about the need to look at the non-punishment principle and its application broadly. And she mentioned very specifically things like interdiction, the use of boats, and other forms of non-traditional or ad hoc forms of detention that are often not recognized. And she also specifically mentioned the case of Hungary, which is one of these countries where people are being detained in transit zones at borders, and the state refuses to recognize that this is actually detention. That must be quite a challenge to approach states that don't recognize these forms of detention as detention. And how do you go about trying to convince them that in fact this is, and this is a principle that applies in these cases? Thank you very much.
Thank you, Mike. Maybe we can already, there's one more question. I raised it already, and then maybe Clara, you can react, and then afterwards, Tiffany. There's one more question of Marie-Isabel Pelham, and she said, thank you to the presentation. That's for you, Tiffany. Could you please elaborate on the 3 approaches identified on your first slides and the challenges associated with each of them? So, but I give first the floor now to Clara to answer the questions of Mike.
Thanks so much, and thanks so much, colleagues, for the invitation to participate in this webinar and the opportunity to be here and to answer some questions and further engage with civil society. So, to answer to your question, to the last question, referring to these other ways of detention that states tend not to call detention. And I'm actually maybe going to add another one that it's, in our case, even more difficult to raise maybe with the states, is that we also find victims are detained in what it's called safe homes. And this is done as part of their protection mechanism of a state. And it's done, they're not just even considered transit center. This is really like shelters, so-called shelters for victims, where victims can stay for very long periods of time, sometimes indefinitely, and it's done in the name of their protection. So that's maybe a one step further in how difficult it is to convince the states that that's not an approach, a human rights and victim-centered approach. But to answer to the question of immigration detention, and also maybe with going back to the first question about what is the sense with the states when we discuss with them in interactive dialogues. When the report was written, and before the report was written, also through the engagement of the previous rapporteur, Marigazza Marinano, who already started this work on the application of the principle of non-punishment, we wanted to be sure that when the report was going to be written on an approach in the implementation of non-punishment, that we were going to be wide in the approach and not just referring to criminal. And it's true that when we look into the application of the principle, the first thought that we have is this application in the context of a criminal procedure, because it's true that many of the cases that we get, we're talking about victims that are engaged in a criminal activity as a direct consequence of trafficking, but instead of being considered victims, they are considered offenders and are treated as offenders. We made sure in the report and in our engagement that we are referring to all forms of punishment, and all forms of punishment mean immigration detention, retention, if we want to call it something, in transit centers, which we still call in our reports, in our engagements, as detention centers for migrants, but also other forms of punishment like refusal of asylum, entering into the asylum process, or deprivation of citizenship, which is quite a la mode lately, I would say. In the exchanges with the states, I mean, sadly, we see changes happening everywhere where there is more and more pushbacks on migrants, and we keep repeating, we consider this as a form of punishment, and that is not, and that is also directly linked, as the Special Rapporteur was saying, with obligations of protection of the state and early identification. And as the Rapporteur mentioned, when migrants are in a detention center, call it detention center, call it transit center, call it hotel where you stay for a long period of time without access to protection, this is a form of punishment, and this is preventing the state to perform an identification process that will allow victims to receive the protection that they are entitled to. I don't know if I answered the question. Please tell me if you want me to go in more detail into any aspect of it.
That's helpful. Thank you very much. Thank you.
Thank you, Clara. Tiffany, do you want also to react to the questions of Mike and also to the last question I just raised?
Sure, thank you very much. Clara said already a lot, but yeah, I totally agree that, and to reply also to the question in the chat, that the idea of having a victim or survivor-centered approach, a human rights-based approach, is that we have to try to put the needs of these people who have already suffered really at the center of responses. And clearly, when they are under any forms of detention, it cannot be appropriate. And what we saw some years ago was really that most of the time at the intergovernmental level, victims of trafficking would have committed offenses, would be treated as offenders. And we see an evolution, I think. Especially the report of the UN Special Rapporteur, actually, I think really pushed the discourse further. And maybe now we have more discussions about the threshold of severity or the scope of the concept. But it seems that the concept itself is understood, and that there is a better understanding that that victims and survivors should really be supported, assisted, and protected as an obligation of the state. I hope I answered.
Thank you. Just one more question, because as you also mentioned, identification is very difficult. And you also refer to the UNODC report of 2022, mentioning that victims themselves very often identify themselves rather than that others identify them. Yeah, can you say a little bit more why this is the case? Also because, of course, if people are not identified, it's very difficult also to apply the non-punishment principle.
Yeah, I think it's a very strong positive obligation of the state, for the reason that in many cases, victims of trafficking don't know that they have rights. They don't know that they can access services. And also very often we see that victims of trafficking fear law enforcement, and many times rightly so. They might be coming from a country where law enforcement cannot be trusted, or they might have committed offenses and they are also afraid of being charged or deported. So for these reasons, they might prefer to not say anything. And another issue is that if they start having a criminal record, they might have further difficulties to reintegrate in a society. So we see a lot of fears, and rightly so, because the legislation on non-punishment is really uneven in the world. And even when it's there is a very inconsistent application of the law. So for these reasons, it's very important that really law enforcement or like officials themselves identify, detect victims to refer them to services.
Thank you very much. Yes, and also what we see very often in practice, also because our members work on the ground, we also see, of course, that any support is still very closely linked with the criminal system, and also there's no guarantee. So that's also, and I think that many people would agree with me online, we really have to ensure that there's more unconditional support, a social path, also for victims to say when they do want to work with the authorities, that they also can guarantee that they get the access to support, and not if they are finally out of detention, are just returned home, because yeah, that's not the support we would look for. I would, because of a matter of time, I would go to the next panel, and then I'm happy that you are still online, and also Clara and her other colleague is also still online. So in case that people still have questions, I was just informed there are no more questions, we can still get back to you in the last round. We also invited Matthew Gillett to speak, but unfortunately he's not able to intervene. So we leave it here, and we go now to the second round. The second panel will focus more on the regional experience. We will hear first from Ambassador Yuyung Wayung-Grum. She's chair and representative of Indonesia to the ASEAN Intergovernmental Commission on Human Rights. She has 30 years of experience working in human rights organizations, both at the national, regional, but also at the international level, and including also for the Human Rights Working Group in Jakarta, the Oxfam International, also in Jakarta, the Forum Asia, Child Workers in Asia, the Solidarity Center, and the National Commission on Child Protection, all in Jakarta. And she also has been the team leader of the regional AU-ASEAN Dialogue Instrument on Human Rights Facility from 2015 to 2017. She has done a lot of influential piece of writing, which often appears in the Jakarta Post, Bangkok Post, The Nation, and Talking Asian, and in academic journals. And her last publication was published in the Journal of Human Rights. So without further ado, Ms. Ambassador Wayung-Grum, I would like to give you the floor, and also to provide us with an overview of the application of the non-punishment principle in your ASEAN region, and also maybe you can give us examples of how countries, different countries in the region, have incorporated it into their national legislation, with, of course, still the specific focus on immigration, detention, and migration. And maybe you can also tell us a little bit more about the role of the AICHR in tackling human trafficking, and also again explain how CSO NGOs can engage with such a regional body. The floor is yours.
Thank you very much. Good afternoon here from Jakarta, and good morning for you. I've prepared a presentation for this. All right. Here. Right. So again, thank you very much. This is very timely discussion. We have discussed this not so much in the region, but gradually we have started the discussion on this. The non-punishment provisions is included in the ASEAN Convention Against Trafficking in Person, Article 14, which requires states parties to consider not holding victims of trafficking in person criminally or administratively liable for unlawful act committed by them if such acts are directly related to the acts of trafficking. In terms of domestic laws in the region, some countries make the non-punishment provision explicit and some not. For instance, Brunei Darussalam, Indonesia, Law PDR, Malaysia, Myanmar, Philippines, and Thailand make the non-punishment principle provision explicit in their laws. But Singapore, Cambodia, and Vietnam do not have explicit provision in relation to non-punishment. So if we look at how non-punishment has been reflected in the law, perhaps we can divide it into compulsion model and causation model. Indonesia, for instance, put the non-punishment principle in the law as long as it is not voluntarily committed, so then non-punishment principle can be applied. While as a direct consequence of trafficking, it's been included as part of the non-punishment principle in anti-trafficking laws of Brunei Darussalam, Law PDR, Malaysia, Myanmar, Philippines. So within these differences, I would like to just mention how the non-punishment provision have scope of protection in terms of limitation. Those who put countries that put the causation model usually have limitation, and especially in the illegal entry, the immigration, or the issue of prostitution, like in Law PDR in Thailand, and many others. So number of limitation offered. So non-punishment principle only can be applied if. So that's the limitation of a condition to apply the non-punishment principle. Last year, ICHR organized consultation with the National Task Force on Anti-Trafficking in Person in 9 countries minus Myanmar. And we have a number of challenges as expressed by the practitioners. So different definition of trafficking in person and different ways of identification of victims create a lot of challenges in applying the non-punishment principle. Lack of understanding about principle of non-punishment principle on trafficking in person, especially in Indonesia, has created a lot of problem as well. So among the practitioners, they discuss that because different definition of trafficking person, many of the victims that considered as victims in Indonesia, but rather perpetrators of violating the immigration law or victims of the labor law in Singapore, make it difficult for Indonesia and Singapore to work together to apply non-punishment principle. Adding to the fact that Singapore has no non-punishment principle provision in anti-trafficking law, but there has been number of gradual acceptance that non-punishment principle is very important to address the issue, but each country has a different entry point. But basically, different definition on trafficking in person, different method of identification of victims become the key problems that these actors, the task forces, face at the daily basis. Some countries like Indonesia that has non-punishment principle included in the law still got confusion on how to implement that. So in number of discussion, the officers from Indonesia continue to raise the need of having guideline on how to apply the non-punishment principles into their work. In terms of the role of ASEAN Intergovernmental Commission on Human Rights, freedom from being trafficked has been guaranteed under Article 13 ASEAN Human Rights Declaration. It is therefore addressing the measures on anti-trafficking becoming one of the priorities of ICHR. We have now a complaint mechanism that was established in November 2019. We call it as the 3 steps communication complaint mechanism. So we receive complaints and we respond the complaints, but if the complaints related to one country, then that country in question should be the one to address the problem. So this is not necessarily ideal mechanism of complaint, but this is something that we have agreed in 2019. In terms of engaging member states, we have at least 3 platforms in which we can talk about the issue. First, inside the meeting of ICHR. ICHR meets 4 times in a year. So in each meeting, we have the agenda item to talk about our concerns on human rights, including on the issue of trafficking. And we have the annual human rights dialogue, which ICHR engage with member states on our concerns. And we also ask questions to member states in relation to human rights issues. And another one is the annual interface meeting between ICHR and the foreign ministers, usually happen every July or August. In this kind of platform, both ICHR share the concerns as well as the ASEAN foreign ministers also share the concern for ICHR to take care. And in our 5-year work plan, we continue to have some initiatives to complement the work of SOMTC. SOMTC is a near official meeting on transnational crime, dealing with trafficking in person. ICHR has done a number of activities. For 2021-2025, we have included referral system, country learning visit, as well as the implementation of the whole work plan. So the non-punishment principle initiative for raising awareness, capacity building, sharing of information had been included in the Bohol Work Plan 2.0. 2.0 means here is the continuation of the work plan after finishing the previous one. So that's my presentation. Thank you very much.
Thank you very much for your presentation and also for explaining further again about the non-punishment principle in your region, the scope of the protection, but also again the challenges which we also heard from the earlier speakers, again, the lack of understanding of the principle, the fact that victims are still often seen as perpetrators instead of victims. And you also highlighted that part of the cause of all this is the different legislation, the different application of the legislation in practice, but also the fact that still some countries do not have the non-punishment embedded in the national law. And you called, if I recall correctly, also for further guidance on this issue. So thank you very much for that. We would now go immediately to the second speaker, also that we then have sufficient time for the Q&A, and I know that there were some more questions in the Q&A session, so your questions will be dealt with in the next Q&A. Apologies for that. So the next speaker on our list, and now we go from the international instrument and the regional scope, actually we go to Europe, we go to the UK, and the next speaker is Catherine Meredith. She's a barrister at Doughty Street Chambers in the UK, and she's a leading human rights and trafficking specialist, and her expertise covers public law, anti-discrimination, asylum and immigration, and also immigration detention and women and children's rights. She handles complex public law and private law claims, often also involving multiple state agencies and the intersection of civil and criminal law, domestic, European and international law. And she has acted at all levels up to the Supreme Court, both European courts and international fora, and her high-profile novel cases have broken new ground for the first time. She will explain with the use of case law, I hope, some examples, how the non-punishment principle applies now in the UK and how lawyers have been able to protect victims of trafficking from immigration detention until today. And I say in particular also until to date, as we all know about the proposed illegal migration bill in the UK. And she will also explore how this new illegal migration bill would remove protections from victims of trafficking who enter the UK illegally and how they would face automatic detention and also removal. And so she will also explain what this means for the UK obligations under international, regional and domestic law. You have the floor now. I know you also have a presentation, but you have the floor now to start. Ms. Meredith.
Thank you so much, Suzanne, for overly generous introduction and for your brilliant moderation, and Rachel and colleagues at the Global Detention Project. It's really a privilege to speak in this webinar. I'm just going to try and share this share the screen. Can you see? Okay, it's a bit small.
Yeah, we can see it, but maybe you should put it on video on the show that everyone just sees the slides. Yes, now it's correct.
Thank you. Okay, great. Thank you. This short presentation will, Suzanne, is that seen properly okay there now? Great, thank you. This short presentation, or my brief, is to provide a national example, the UK, but as Suzanne has already indicated, it is an unfortunate example. In order to understand why, and through the lens of the non-punishment principle in immigration, in immigration detention cases, it's important to know where we have come from, legally speaking, and where we are going to. I take this in 4 stages. First, what is the victim protection framework in the UK under the Council of Europe Convention on Action Against Trafficking in Human Beings, ECAT, international law, and international and domestic human rights law. Second, how do the protective provisions of ECAT and the ECHR, the European Convention on Human Rights, including the non-punishment and penalisation principle, apply to adult and child victims of trafficking in immigration detention in the UK? Third, how has that framework of protection under ECAT already been curtailed or disapplied in UK law in the last 2 years, 2021 and 22, including under a Nationality and Borders Act 2022? I'm going to call that the stage 1 dismantling of victim protection. Fourth, how that stage 1 dismantling of victim protection has broken in or laid the ground to stage 2 dismantling in the illegal migration bill. Be in no doubt, this is a national project aimed at removing protection that has been afforded to victims of trafficking generally. It is designed to increase detention and removal, and it is an attack on democracy and the rule of law. These are not just comments from myself. These are comments that have been made by the UNHCR, UN experts, including special rapporteurs, 2 former prime ministers of the United Kingdom, including one Conservative minister, Theresa May, and there are universal criticisms. This is taking us back pre-ECHR. So be in no doubt about where the UK is going to, and what that means for victims of trafficking. I will try to share a snapshot now. In terms of the UK structure and how the illegal migration bill and legislation is an aim to try to reduce protection, it's important to understand, as I say, what the overall framework of protection is in the UK. ECAT, the Council of Europe Convention, was signed by the UK in 2007 and ratified in 2008, but there is no ECAT Act of Parliament. It just applies piecemeal. That's because the UK has a dualist legal system which gives legal effect to international treaties only to the extent provided for in Acts of Parliament, and they don't automatically take effect. So generally speaking, the rule of law requires compliance with international obligations and international treaties. That's an age-old principle of the rule of law, and it's a principle of the Vienna Convention on the Law of Treaties. But as I've said, ECAT hasn't been given effect to in any Act of Parliament per se. there have been piecemeal approaches to lay down criminal offences in the Modern Slavery Act 2015, as well as defences, giving effect in part to the non-punishment principle in Article 26 of ECAT. However, in terms of the mechanism for identification and protection of victims in the UK and the protection of victims in immigration detention, that is all governed by policy guidance. And that's been the case since the national referral mechanism in the UK. The mechanism for identification and protection commenced on the 1st of April 2009 to give effect to ECAT. And if that policy purports to give effect to ECAT and fails to do so, we lawyers have been able to challenge the government in the courts. So that has been the framework in which lawyers have challenged immigration detention and other aspects of the denial of rights of victims of trafficking in the UK by challenging the application of policy or the legality of policy. It's also important to know that in the UK, the ECHR is given effect to domestically in UK law, UK legislation, the Human Rights Act. And that means in immigration detention cases and in other cases, we can bring challenges for breaches of the ECHR. For example, relevantly, Article 4 ECHR interpreted in accordance with ECAT in line with the principles of the European Court of Human Rights. And that would include the three key Article 4 duties: the systems duty, the operational or protective duty, and the procedural or investigative duty. And similarly, there may be issues in detention under Articles 3, 5, 8, 14 ECHR as appropriate. Now, that is important to know because for over a decade since the commencement of the NRM, the government has resisted all calls to put the NRM and victim protection on any statutory footing whatsoever. And the Council of Europe group of experts on action against trafficking in human beings, the monitoring body of ECAT, has observed that in the reports on the UK. So the very first time that the UK has chosen to put victim identification protection anywhere near any piece of legislation was only to reduce it. And that was in the 2022 Nationality and Borders Act, which redefines victimhood and reduces or stops victim protection in certain circumstances. The general framework for the protection of victims in detention can be described in short as I should caveat, I had it on the slide at the outset, this is a highly regulated area in UK law, and so this is only a snapshot, but broadly speaking, the detainer must justify, the principles are that the detainer must justify detention by references to the constraints on the statutory power to detain, including constraints under human rights law, as informed by ECAT and international treaties, policy guidance, etc., as well as constraints under the common law, judge-made law, rooted in false imprisonment and habeas. So a whole corpus of law going back many, many years. And at the forefront of our mind here are the principle that the UK courts have accepted that the Article 4 ECHR operational duty to protect victims of trafficking in detention can be triggered where there's a credible suspicion of trafficking. And as such, Article 4 ECHR is read with ECAT and the case law of the ECHR and applies in detention and trafficking cases. If that trafficking protection duty is triggered, then that may require a victim's release, their protection and assistance, their identification, and special protective arrangements on release to prevent victims being released to the streets or into the hands of traffickers. And there's a very important case in the Court of Appeal in the 4th bullet point there called TDT against the Secretary of State for the Home Department, SSHD, which goes through that line of Article 4 ECHR authority and sets out that protective trigger on Article 4 ECHR, the protective duty. In the case, in terms of the non-punishment principle, in VCL and AN and the UK, which the Special Rapporteur already spoke of today, the European Court of Human Rights held essentially that the non-punishment or penalisation principle fell within the scope of the Article 4 ECHR duty to take operational measures to protect. However, that duty was breached as a result of the failure to promptly identify and protect child victims who are the subject of prosecution for offences arising from their status. Now, it could be argued, and it has been argued in practice, that the non-punishment principle or non-penalisation in administrative detention, immigration detention, that principle could practically apply under Article 26 ECAT, informing Article 4 ECHR, that it could inform the question of whether or not the detainer has justified the detention, whether the detention is unlawful, whether there has been a false imprisonment, whether the victim should be released, and whether the person is entitled to compensatory damages, and if so, to how much. And so that argument, that line of argument has been used and sometimes does come up in practice in cases with similar fact patterns, mainly to the fact pattern in VCL and AN the UK, involving victims of trafficking who had not been identified promptly and correctly and who had instead been subject to wrongful prosecution. As regards children, as we know, there is a heightened or there are enhanced or heightened specific protections available to child victims of trafficking, or afforded, not available, but actually required to be provided to victims of trafficking who are children. And that's almost universally recognised, or is universally recognised in ECAT, the EU Trafficking Directive, in the case law of the European Court of Human Rights, and also, I'm happy to say, has been reflected in UK law and policy. Those ECAT protections have been bolstered in the UK by other provisions of domestic children's law, informed by the UN Convention on the Rights of the Child. And since 2008, particularly, in particular, after the UK announced that a restriction was being lifted on the UNCRC, the Convention on the Rights of the Child, regarding immigration, UK immigration and public law regarding detention has developed in a way that the protective framework has it's been designed to operate to prevent children and child victims of trafficking from being detained, either in families or if they are unaccompanied asylum-seeking children, or separated children, or even in age-disputed cases. And generally, there is a principle accepted that a child should be presumed a child unless there's a lawful verification to the contrary. And there's been a whole load of challenges to that, to unlawful detention of children who have been presumed to be adults wrongly. Those cases that have come to the courts more recently are cases where the framework has broken down, and generally lawyers have brought successful challenges in the courts. So far so good, but where are we now? Victim protection as we know it has already has already been dismantled. This is what I've said is the dismantling point 1.0. That dismantling has occurred in the Nationality and Borders Act, in trafficking policies, where the UK government has said in the new plan for immigration that victim protection structurally has been subordinated to immigration enforcement in a way that there was always there was always that tension, but it structurally has been subordinated in the way that the Home Office deals with trafficking policies and in the way that policy operates. So this is a matter of institutional competence in the way the policy has been written, the operation of the NRM, and it's a fundamental structural change. This regressive move to subordinate victim protection to immigration enforcement, it includes immigration detention. And this was cemented in Part 5 of the Modern Slavery, Part 5 Modern Slavery of the Nationality and Borders Act. The Act entered into force in April 2022, but Part 5 did not enter into force until the 30th of January 2023. But by that time, there had already been changes to the policies that govern victim identification and protection. Relevantly for immigration detention or victim protection generally is a key change in the policy that is designed to give effect to ECAT that raises the threshold for victim identification at the earliest stage. That's the reasonable grounds threshold. Now that threshold has been raised, and that means in immigration detention cases, the trigger for release has become higher. So if it's harder to get a positive reasonable grounds decision, it's harder to establish the reasonable indication for release. More victims will be wrongly deemed not to be victims and will remain in detention. And that change is both in the modern slavery statutory guidance, and it's also in the detention policy concerning victims of trafficking, which I've included on the slide. I've included the far-ranging provisions that have already been brought into force, and I've provided some links there for anyone who's interested enough to read them. And finally, the dismantled victim protection stage 2 in the illegal migration bill. It's very difficult to encapsulate what this is all about in a nutshell, bar saying that what it's about is the Prime Minister has promised, this is in a statement to Parliament, the British people, that anyone who enters the UK illegally will be detained and swiftly removed. The government has accepted that it is not compatible with the European Convention of Human Rights. The bill will also break the law, and it will remove access to the courts, and it will threatens not to comply with interim measures of the European Court of Human Rights, and threatens the global system of refugee protection. There's a whole range of very far-ranging provisions, as I've indicated. Clauses 21 to 28 concern modern slavery, specifically providing for removal of victims with a positive reasonable grounds decision, denying support and assistant measures if a person arrived illegally and did not come directly from their country of prosecution. And this goes further than the 2022 Act. The government purports to justify these provisions on the basis that the NRM is being abused, but the government has refused in 2 years to provide any evidence for these claims. And detailed research by academics, including at the University of Nottingham Rights Lab, have shown that on the government's own statistics, 9 out of 10 victims are positively identified. There is distorted language and the creation of a fake crisis, with the Home Secretary claiming that this is not scapegoating, but protecting the vulnerable. And this is part of a larger global migration crisis. And it's just universally criticised, as I've mentioned, by former prime ministers, by social workers in respect of provisions regarding children, and by UN and Council of Europe experts. it is an attack on the rule of law, which is particularly important in including in detention cases. And I think I shall stop there for fear of dissembling into a rant, and happy to take any questions. Thank you, Suzanne.
Thank you so much. Indeed, there are already some questions, and also what we would like to do now, because this is the last Q&A to start, we would like to hear also a little bit from the audience. Also, maybe there are some specific questions also related to practice, maybe in the UK, because they have to deal with the situation there. And thanks very much for explaining very well what was the impact of the illegal migration bill, and also how the current text of the Council of Europe of Convention is now used also to protect people from migration. But I understand it's a very difficult issue. So there is a question, but before I go to the question, I would like to highlight to everyone, we have actually 3 questions still remaining. I would like to highlight to everyone that in case there are immigration detention advocates in attendance who can share their experience attempting to use the NPP in their efforts to help migrant detainees, or to address whether they see opportunities for its use in their countries, then please also use the Q&A, also if you want to raise questions. And we would like also to hear a little bit from others that maybe have some successful cases, because we think that the audience can also learn from that. But maybe there are also more questions to you, Catherine, about your presentation. Before I give the floor and I ask the speakers to answer the questions that we have now, I would like to invite my colleague from Astra, the director of Astra in Serbia, to shortly speak from the audience. Her name is Maria Angelkovic. Maria, can you speak?
Yes, can you hear me?
Yes.
Yes, thank you, Susan, and thank to the all presenters for the excellent presentations and implications of the not using non-detention principle, non-punishment principle to victims of trafficking and potential victims of trafficking, and explaining how it's going in the law and how it's going in the practice. And I just wanted to share 2 cases from our practice that actually will illustrate what we have heard until now from the previous speakers. My organization, Astra Anti-Trafficking Action, is providing assistance to victims of trafficking in the Republic of Serbia since 2000. And in our practice, we had several cases of detention and prosecution victims of trafficking. Most of these cases are related to young people who were trafficked for the purpose of committing criminal acts, but also victims of sexual exploitation who were forced to commit different criminal acts for their traffickers. And some of these cases, unfortunately, ended up with the jail sentences for more than 10 years of jail. And this was the reason why the Serbian Prosecutor Office initiated adoption of the OSCE guidelines on the application of the principle of non-punishment of victims of human trafficking in 2014. In 2010, my organization Astra assisted to 2 Uzbek women who were recruited by false job ad and with a real aim to be sexually exploited in Italy. And they were traveling with their trafficker who took their passports via Albania and Kosovo, and they entered Serbia with the false documents. They were immediately detained and sent to the migration detention near Belgrade, while the trafficker managed, of course, to escape. Astra received the first information about this case from the NGOs from Kosovo and Albania, and we informed immediately institutions about the situations and indicators of trafficking in this case, but there were no positive reactions until we actually informed the ombudsman protector of citizens, who immediately reacted. And based on the law that was valid in that time, he engaged Astra as an expert on trafficking to identify indicators of trafficking, and he managed immediately to release these 2 women from the detention based on our findings. And actually later we count that later we count that they were in contact with 28 officials before they were detained. So I'm trying just to illustrate what was said previously, that actually early identification is really important. We don't need to come to the detention, actually, if we do our jobs correctly. So the proactive and early victim identification is crucial to successfully implementation of the non-punishment principle and referring victims to services they need, actually. And the second case is dating from 2017. It's a case of a 16-year-old girl from Cameroon who was sent to detention as an illegal migrant. She asked for asylum, explained that she was forced by her family to marry a 60-year-old man as his third woman, and who raped her several times. Her brother actually helped her to escape and she tried to get to the US where she had some relatives. She went to Turkey, and after she was late for the US flight, she met a man from Nigeria who helped her to go to Serbia and later to Italy. And in Italy, she realized that she lost her passport, or her passport was stolen, but the Italian police didn't believe her. They beat her and sent her back to Serbia. So the asylum committee, actually, she asked for asylum in Serbia, and the asylum committee in the first instance, they rejected her request. Even they were presented with a fact sheet on the position of the women and girls in Cameroon from 2000 to 2010. We presented trafficking indicators. We presented that she couldn't report rape in Cameroon because she would say that she needs to deal with these family issues with her husband. She never approached the officials in Turkey, Serbia, and Italy because she didn't trust and she was afraid of institutions, especially after she was beaten by the police. And also we presented that she had a primary school degree with no enough information on her rights. In spite of all this, asylum application was rejected. With the explanation that she traveled 22 days through Turkey, Serbia, and Italy, and she never complained and asked for asylum before, and explained her situation. In the appeal procedure, ASTRA provide the official identification by the state institution according to the state-adopted indicators and got the positive decision of the Appeal Asylum Committee, and she was granted asylum on the basis of the fact that she is a child victim of trafficking. What is disturbing in this case is that during the whole procedure of the Asylum Committee never considered the fact that they have a child in front of them. And this was really disturbing for me and my colleagues. So she spent 7 days in the detention center, and after the positive decision, she was placed in the shelter for trafficking, for adult victim of trafficking, since Serbia still doesn't have the one for children. Just I want to conclude by this: when deciding on her asylum, on the appeal, actually on the second instance asylum commission, they were particularly guided by the fact that she is an unaccompanied minor, and based on the international law and legal provisions, she represents particularly sensitive category of persons. Also, they were guided by the general comment number 6 on the treatment on unaccompanied minors and separated children. And also, furthermore, they called upon Article 6, paragraph 1 of the Family Law of the Republic of Serbia, saying that impose actually the obligation that everyone needs to act in the best interest of the child. And finally, they quote Article 15 of the Asylum Act, requires that the asylum procedure should take into account the specific situation of the person in need. And both these cases actually shows that identification and indicators should be detected in early phases, and that persons should be approached individually and consider the whole background, not only a rigid current situation, but as an NGO, we also advocate for obligatory legal regulation of this principle in order to be operationalized in most effective way, since guidelines that we have now are not obligatory and not all prosecutors and police officers and other officials are informed about these guidelines. So that's all for now. Thank you.
Thank you very much, Maria. Good to hear also from the practice, as we know and heard a lot about the actually legal situation, but it's also good to again go back to practice. We have two questions, and I just put in the chat that as for the question to the US, I feel that we don't have an expert on the US, so it would be maybe a bit silly for one of us to answer that question. But I referred to the Human Trafficking Legal Center in the US, and maybe the person who raised that question could contact them. They are an expert organization. I have one question for you, Catherine. On the question is, given the alleged increase in modern slavery within the UK, what comments specifically regarding the protection of British victims of human trafficking can be summarized? That's the question.
Sorry, thank you. Well, regarding British victims, clearly, because they do not have any, the immigration is irrelevant to them, then nothing that I've described, nothing really, in terms of the regressive regressive approach to victim protection applies to British victims. So for British victims of trafficking in the UK, they are identified by the single competent authority under the NRM and provided with protection and support from a reasonable grounds decision. The lifting of protection only applies to victims of trafficking with a reasonable grounds decision, where they have also made an asylum and protection claim, and so there are immigration implications. So I think that's the broadest summary, that protections still apply to victims of trafficking who are British. They are curtailed or lifted entirely for non-British victims. And the second point to summarise is that as I indicated on the slides, there is now a two-tier identification and protection system, or even a three-tier. So between 2009 and 2014, the NRM operated with the Home Office making identification decisions for victims who were third country nationals, and the National Crime Agency, which is a pillar of the police force, making decisions for British nationals and for EU nationals. There were complaints that victim identification should not be in the hands of the Home Office, and a review commissioned by the Home Office, by a Home Office inspector, concluded that victim identification protection should not be in the hands of the Home Office because they were conflicted with their immigration priorities. So from 2014, the NRM was reformed, but unfortunately, come 2021 and welcome to 2023, the whole thing has reverted back 10 years. So we have two-tier identification again, with British victims identified by the National Crime Agency, and third country nationals identified by the Home Office. And even worse, there is a subset competent authority for detained victims, which is particularly egregious. And I'll stop there.
Thank you.
Thank you.
Yes, I can imagine, and it's very sad to see now. I have a question to Ambassador Yoon. The question leads, thank you for highlighting clearly the challenges faced at regional level. The current situation in Myanmar is generating trafficking and victims, often unrecognized, that travel through Myanmar or are returned to Myanmar are often punished, especially stateless Rohingya who are charged with immigration offences, either traveling through their own country or after return. Could you please elaborate on the challenges at ASEAN regional level of engaging with Myanmar on these issues? Thank you.
Thank you for the questions. Yes, that one of the headache we face on issues in relation to or engaging with law enforcers. ASEAN has reduced the engagement with Myanmar unless it is with the non-political representative and they are civilian. For the law enforcers, military, we have reduced the engagement, in which trafficking, it has a lot of impact to trafficking issues, because trafficking dealing with trafficking means that we engage with law enforcers. So we do not have spaces or platform in which we can discuss this rather than with the civilian authorities. ASEAN does not recognize SEC as government, so we continue to call it as rather authorities. At the moment, we receive a lot of complaints from Myanmar outside of the country. They have their visas expired and passport expired, and the embassies of Myanmar in different countries do not want to extend the passport unless they return to the countries which give them some risk of being punished or not able to go out the country. For ASEAN has called for ASEAN member states to extend visa for those who Myanmar is migrant in different countries, but member states cannot extend a passport, because passport only can be extended by the country that issue the passport. So we have a lot of problems right now, lead to Myanmar migrants become stateless in different countries. We haven't been able to solve these practical issues. Yeah, so for Rohingyas, individually, this is not the ASEAN official position, but whenever they come to me, I ask them not to go to the country at the moment, even though going home is something that they would like to do, or they really want to go home. But given the situation right now, better not to go home at the moment. They might be seeking refuge to different countries, but we just realized that one boat has been returned to Myanmar by Vietnamese maritime officers. So again, I do not have the answers, but this is something that we have been trying to address day by day.
Thank you very much for answering. I'm conscious of the time. I see that there are a couple of more questions. I'm looking in the chat actually, because I don't have them in the Q&A. There is still a question for Clara and Tiffany. Hello, it's Habiba Kara. I'm working at the Turkish NPM. Firstly, thank you so much for your presentation. As we know, trafficking human beings is widely accepted as a form of structural gender-based violence and the manifestation of discrimination based on gender, in addition to its gender nature. When we consider the patterns of trafficking in human beings, and then maybe it doesn't read longer with me. Maybe Rachel, do you have the full?
Sorry, yes.
Yeah.
She's saying, in addition to its gendered nature, when we consider the pattern of victims of trafficking in human beings, and the detention of victims is a highly racialized phenomena. Thus, I wonder if you think current international legislation, policies, or jurisprudence are adequate to address these dimensions of trafficking in human beings. And Habibe asked this in the first half of the presentation, so I think it's appropriate for Clara and Tiffany to respond to. Thank you.
Thank you. Maybe Tiffany, can you react first? And thank you, Rachel. I now have the full questions on my screen. Thank you.
Yeah, thanks for Habibe for her question, and also nice to know that there is the NPM from Turkey. Yeah, it's a good question, and I think when it comes to the non-punishment principle, we have, like the special rapporteur was saying, we have to go beyond also the TIP protocol, as they are regional instruments, and when it comes to Turkey, the Council of Europe Convention, Article 26 covers it, or the ICJ statute, Article 38. So there are regional instruments that are targeted on this, and also treaty bodies that I'm sure Clara can talk better about. But yeah, I was checking the national legislation of Turkey, and as far as I can see, there is no provision on this principle yet. So this would be better. But yeah, that's what I would say on my side.
Thank you, Clara.
Well, to what Tiffany already said, I can add, I mean, maybe if she can have a look at, and I'm sure she's familiar with the CEDAW General Recommendation 38 on trafficking of women and girls. And I totally agree, detention is a racialized issue, and trafficking as well. In our specific communications to states, we often need to raise the principle of non-discrimination, because we often see that there is clearly an added vulnerability. And we've also raised that in identification, in protection, this needs to be victim-centered human rights approach, and take into account all the vulnerabilities of the victim. And even going a bit further, maybe we can look into identification based not on a story of the victim, but based also on vulnerabilities that may affect a specific person in a specific case, and may facilitate an early identification. So answering to the question, maybe many of the legislation that we see does not address as much as we would want specific questions regarding discrimination or gender. Also, gender understanding not only women, but one aspect that we often need to raise is that there are also, when victims are men or boys, there can be also concerns about under-identification, as well as lack of access to protection, because protection is being geared to a specific type of victim or a specific profile of victim.
Thank you. Thank you, Clara. And also you raised your hands also still in the first round. So if you still want to add that, that's what you wanted to say, that's the time now too. And then unfortunately to everyone, maybe the organizers can still answer some questions that you have raised on the chat or the Q&A. Unfortunately, we cannot answer all the questions because time is short. So this will be the last, and then we're going to the closing because we know that all of you are extremely busy. So Clara, take the floor.
Thanks so much, and I'm really gonna not try to take much time. I want to thank Maria from Astra, because she actually raised the actual point I wanted to raise. The special rapporteur said in her presentation that we can think that the principle is well acknowledged and well recognized. The recognition is very different from countries. What we see is that while some countries may think, or some practitioners, not just countries, but practitioners think that the principle of non-punishment is sufficiently recognized through the utilization of the duress clause, for example. When we think about specific about cases of trafficking, or specific about cases of trafficking of detention in migration of victims of trafficking, this is too late. Because the duress is something that will be raised in a criminal proceeding, and that's already too late for victims. So as Maria said, the concern is maybe not so much that the principle is recognized or not, but this is applied too late. When someone is already going through a criminal proceeding, this is too late. When someone is in detention, it's already too late. So what we see as one of the main concerns in the application is that maybe the problem is that it's also not so well known outside of trafficking practitioners. And I'm glad that we're having these type of exchanges, because it allows other practitioners to get to know it. So what we would like to see is that the principle is more known among first responders, and that the application of the principle is institutionalized. Because what we see as well is that it's not sufficient just with the training of first responders, because people change positions. And we may go through a set of very well-trained immigration officials and then move into another stage of officials that know nothing about it. So I think it will be great that we continue to have this conversation so it's more known among practitioners that are not only in the trafficking sphere, but also to push states to institutionalize it at the very beginning when we receive migrants at our borders. And this is part of these SOPs to the recognition of specific vulnerabilities among migrants that arrives. Thank you.
Thank you so much. I was muted. Thank you so much for this addition. And definitely, I think everyone agrees with me that we would love to further work with your office to raise alarm about the non-implementation of the non-punishment principle and to ensure together that there's much more awareness. Of course, the reports by the UN rapporteur and also the former UN rapporteur have contributed to that. I think maybe we can also still share some reports were already shared in the chat. And there's more. I would also like to highlight that we at La Strada International has set up a members group of members who want to work more on the issue of non-punishment, in particular the application. And as Maria also said, Astra is one of our members. We would like to look also specifically into cases. We want to do some stakeholder mapping and to really together promote it and then to really show the legal practitioners and also others where it works, what does it not work, and how it has to change. And then also to repeat the words of the UN Special Rapporteur, it should be implemented as soon as possible. Let me just only still thank all the speakers, including also you, Clara, but also Professor Shifon Mulali, Ms. Tiffany Grittit from the Human Trafficking and Migrant Smuggling section at UNODC, Ambassador Yuyun Wayung Grum, and also lastly but not least, Catherine Meredith from the UK. I would now to hand the floor to Mike. Mike, for you to formally close this webinar.
Thank you very much, Susan. And thank you very much to all the speakers. I had a lot of things I was going to wrap up with, but Susan, you and Claire, you have both stolen my thunder, and I think you've done it much better than I could have done. I would focus attention on the issue of awareness and implementation and institutionalization, which I think you raised, Clara, with respect to this principle. I can say from our point of view at the Global Detention Project, one of the things that has been striking for us as we've considered the issue of non-punishment and immigration detention is just how little aware we were of the principle and its application. And one of the things that was striking about this, an anecdote as we were putting this together, and something that Catherine, you clarified in your response discussing the protections for British victims of trafficking, is that there's a really important distinction to be made between victims of trafficking who are citizens and those who are non-citizens. And there is this extraordinary vulnerability that non-citizens face when they're trafficked. And it's not only awareness of the principle that is going to help them, but it's also, as many of the cases we heard today, Yuyun in particular talking about the return by Thailand people to Myanmar, it's a will, it's a care and a will on the part of officials to actually implement it, whether or not they're aware of the principle or not. And I think that that's one of the major struggles we're all going to face going forward, is not only making sure that officials are aware that this principle exists and should be applied and how it should be applied, but to constantly pressure them to care that this is something that should be done. And I think that's where organizations like the Global Detention Project, like many of the organizations have been today, attending today, can play an important role. And I would leave us with that message that this is something that we need to be doing much more effectively. In any case, I'll wrap up with that. And thank you very much to all of you for these great presentations and for the great questions. I look forward to hearing you. Oh, also, before I go, just to remind you that we'll have a recording of this event that you'll all be given a link to, as well as links to the different presentations and supporting documentations after the event, in case you were wondering. Again, thank you very much for attending, and I look forward to being in touch with you all at some point in the future. Take care. Bye-bye.